Tonight I'll be talking about superannuation and in particular discussing some of the estate planning implications of owning assets within this structure. So we'll look at firstly who can actually receive a benefit from superannuation, how do we go about ensuring that our preferred beneficiary receive that benefit, and also the tax implications of different beneficiaries receiving a superannuation death benefit. But before we do that, I thought it would be just important to look at firstly what is superannuation and why do we focus on superannuation as a retirement planning tool. Many people refer to superannuation as an investment, and it's quite common for us to hear reports where XYZ superannuation fund has returned X% over the past 12 months. Now, unfortunately, this gives a lot of people a false representation of what superannuation actually is. And in more recent times where investment earnings haven't been as kind as what we would have liked, a lot of people have lost confidence in superannuation. But the important thing to make note of is that superannuation isn't an investment, it's a structure. So what that means is that it's a vehicle that we use to own assets for the purpose of providing for our retirement. So why do we focus on superannuation as a retirement planning tool? I guess one of the major reasons for that is that superannuation is the most tax efficient structure to accumulate and preserve assets for your retirement. Investment earnings are taxed at a maximum rate of 15%, and when you retire and start drawing an income stream, those earnings are completely tax-free. So you can start to understand as why advisors do focus on superannuation so much as this retirement planning tool. And I guess the reasons why, or the reasons that I've just explained as to why we focus on superannuation really drive the reason that superannuation is such a large asset for a lot of people. And after their home, it's probably their largest asset or maybe their second asset after their family home. So it's important that we do give consideration to superannuation as an estate planning issue because it is such a large asset. And one of the major issues that perhaps a lot of people don't realise is that superannuation doesn't actually form part of your estate. So that means that it isn't automatically dealt with via your will. So it is important that we view superannuation separately and consider the estate planning implications of having significant assets within this structure. So firstly, who's entitled to a death benefit from superannuation? There are restrictions on it. They're limited to your current spouse, whether that be through marriage or a de facto relationship. It can be a child of any age. It can also be your legal representative. So there are ways that we can have superannuation dealt with via our wills, but we have to make sure that we make that specific nomination, which I'll go through in a few moments. It can also be a person who's financially dependent upon the deceased. And finally, it can also be a person in what's called an interdependent relationship. Now, this final point I'd just like to spend a few moments on because it really does broaden the number of people who can have a claim on your superannuation benefits or who can be a beneficiary. And the best way to look at this is through a case study. So in this particular case, we had a young man who was 18 years of age, had superannuation benefits. He didn't have any dependents, he wasn't married, didn't have any children. So in this particular case, the trustee of the superannuation fund, who had ultimate control as to where those benefits were paid, awarded the benefit to his mother, brother and father. However, he also had a girlfriend who made a complaint to what's called a Superannuation Complaints Tribunal on the basis that she was in an interdependent relationship. Now, in order to satisfy that definition, she had to meet 4 criteria. Now, the first one of those was that they were in a close personal relationship, which was quite obvious in that they'd been together for just over 2 years. So she satisfied that particular point. The second one was that they had to be living together. The young man had recently just moved in with his girlfriend's parents, so they were living together. And up until recently, prior to his death, he had to be paying a small amount of board to his girlfriend's parents. The third point was that one or each of them has to provide the other with financial support. Now, although the girlfriend admitted that they didn't have any joint accounts or own any joint assets, she could prove that they were sharing bills with each other, so they could satisfy that particular criteria. And the final issue was that one or each of them has to provide the other with domestic and personal care. And she claimed that they did share domestic duties. So in this particular case, because the other family members weren't claiming that they were in a dependent relationship with their son, because they couldn't satisfy that criteria, they had to prove that the girlfriend, in fact, wasn't in an interdependent relationship. Now, the finding by the Superannuation Complaints Tribunal was that, in fact, the girlfriend was in an interdependent relationship with the young man, so they awarded 100% of the benefits to her in this case. Now, a lot of you may think, look, an 18-year-old probably doesn't have a lot in superannuation anyway, so why bother about it? But it's important to bear in mind that a lot of default superannuation funds actually have minimum levels of insurance, which can range from $50,000 to $100,000. So even for young people, whether there's young people in the audience or your children or grandchildren, it's even important for them that they do consider the estate planning implications of having assets within superannuation. So how can we go about ensuring that our beneficiaries receive benefits from our superannuation fund? There's really three ways that we can make a nomination for our beneficiaries. The first one being what's called a reversionary nomination or a reversionary pension. Now this basically involves an individual who's probably already receiving an income stream from their superannuation fund. So a reversionary beneficiary basically enables that pension to automatically revert to their spouse. So it's a simple way for the benefit to be paid to a dependent spouse or other dependent. Now, one of the advantages of this nomination is that the funds are retained within superannuation. So after the death of the individual, it retains the benefits or the tax incentives of having money within superannuation. And secondly, and probably just as important, is that particular nomination is a binding nomination. So the trustees of the super fund have to follow that nomination. The second way to make a nomination is what's called a non-binding nomination. Now, this is probably one of the most common nominations for a lot of people, whether they have an industry fund or even a self-managed superannuation fund. Now, this particular nomination is actually dealt with via the trustees. So it's the trustees of the superannuation fund who have the discretion and control as to who receives that benefit. So there's a bit of a lost control here for the individual. The final nomination is what's called a binding death nomination. Now, if the trustee of the fund allows it and if it's a valid nomination, there are ways to have a binding nomination where the trustees have to follow that particular nomination. Now, once again, the best way to look at this is firstly to look at some issues surrounding those nominations. First of all, as I discussed, the non-binding nomination is providing the trustee of the fund with ultimate control, and that trustee could be a third party. So obviously the individual loses a lot of the control as to where those benefits are being paid, so potentially not an ideal outcome. And secondly, if you're operating a self-managed superannuation fund and the trustees pass away, it's the executors of their estate who step in and act as trustees of that fund. So once again, the individual is losing control as to where their benefits are being paid. So there's obviously some pretty strong issues there that we need to deal with. Now, the best way to look at these issues is to look at a case study, and this was an actual case study, Katz versus Grossman. Now, in this particular case, we had Mr. Katz, who operated a self-managed superannuation fund with his wife who'd recently passed away. So he actually brought in his daughter to act as a second trustee of the fund, because that fund has to have at least two trustees or a corporate entity. So in this particular instance, he's brought in his daughter to act as a trustee. Now, as part of his estate planning, he made provision in his will for 50% of his benefit to be paid to his daughter and the remaining 50% to be paid to his son. Unfortunately, Mr. Katz passed away, and the daughter, being the sole trustee remaining, decided to bring in her husband as the second trustee, and in their wisdom they decided to pay 100% of the benefits to themselves and run away with the super benefits. A lot of you probably think, how can that happen? But it's actually, as I said earlier, it's the trustee's discretion to pay the benefits to whomever they choose. Now, in this particular case, it was Mrs. Katz's daughter and her husband who were the remaining trustees, so they had complete control. They weren't breaking the law in paying the benefits to themselves. And the son really had no legal action to take because of that particular issue. And this particular case did go through the courts and cost several hundred thousands of dollars, to no avail. The son was actually left with nothing in the end. So what could Mr. Katz have done to ensure that his benefits were paid out to the people who he wished to be paid out to? And the best thing that he could have done was make what's called a binding death nomination that I discussed earlier. So long as his self-managed fund allowed it, and so long as the nomination was valid, he could have stipulated that 50% of the benefits were to go to his son and 50% to his daughter. So in the case of his death, his daughter would have been bound by the law to follow that nomination. So when we're considering superannuation estate planning, it's important that we give consideration to the appropriateness of a binding death nomination, because it does make superannuation estate planning more precise and more effective. So moving on to the taxation of superannuation death benefits, it's really dependent on two main factors, one being whether the beneficiary is a dependent, and we look at the definitions of these particular issues, and the other one being whether they're a non-dependent, and the second issue, whether the payment's made out in the form of a one-off lump sum or whether it's paid out to beneficiaries in the form of an income stream. So firstly, just looking at the definition of a dependent from a taxation perspective, the definitions are very similar to the definitions that I discussed earlier in relation to a superannuation dependent. The major difference being that it's restricted to minor children as far as beneficiaries being children. So an adult child is actually classified as a non-dependent. So if we're looking at dependent from a taxation perspective, it is limited to the 4 beneficiaries that are listed on the screen. So when we're looking at working out what the taxation implications of paying a superannuation death benefit to a beneficiary, the payments really still have to be broken down into the 2 components of superannuation. So one of the components within most of your superannuation funds will be a tax-free component, so that's any money of your own that you've put in with after-tax dollars. And the second component is what's called a taxable component, so that's any contributions that your employers have made or any investment earnings within the fund. So when we're looking at the taxation of a payment to a dependent, if it's in the form of a lump sum, it's completely tax-free. And that's why it's important that we determine whether the beneficiary is a dependent or a non-dependent, because the tax implications are obviously quite different. Now, if that benefit's paid out in the form of a pension, which is quite common for a lot of people in a married relationship where a surviving spouse is left behind, if that benefit's paid out to a dependent who's over 60 years of age, once again it remains tax-free. If it's paid to a dependent who's under 60 years of age, there is tax applicable. And this is really where the different components of superannuation come into play, because the tax-free component that I discussed earlier remains tax-free, even if it's paid to a beneficiary under 60 years of age. There's also an option to pay out benefits to minor children, and the benefit being that the child can receive up to $45,000 a year tax-free, but more importantly, the major advantage of having a reversionary pension is that the assets are retained within that tax-effective superannuation environment. And finally, if those benefits are paid to what's classified as a non-dependent, so an adult child or someone who's outside of the definitions that I've explained earlier, it can't be paid out in the form of an income stream. And secondly, the tax-free component remains tax-free, so that is a benefit there, and that any money that you've put in on your own to your superannuation fund with your own funds from after-tax dollars remains tax-free even to a non-dependent. But the taxable component of a superannuation death benefit is taxed at 16.5% to a non-dependent. So with all these issues in mind, once again, it really stresses the importance of considering the issues of having assets within superannuation and taking the appropriate steps, firstly to ensure that your preferred beneficiaries receive that benefit, but also being aware of the taxation implications.